Hello and welcome everyone to Crossing the Linguistic Divide, an advocacy and cross-examination training session in English for non-native speakers. We're joined here today by arbitrator and barrister Stephen Lim of 39 Essex Court Chambers. And the purpose of today is a training session on effective advocacy in the English language, even if English is not your mother tongue. Now, I'm obviously very fortunate that it is, and I can't imagine how difficult it is. Advocacy is hard enough for me, so I can't imagine how difficult it must be if it is not your mother tongue. My name is Ben Berry, and I'm one of the co-chairs of HK45. And the training today, of course, is on the art of advocacy for non-native English speakers. Slide 2. Just before we start the training, allow me to briefly introduce you all to Stephen, who's our special guest today, our panelist as well. And also let me just say something about the HK45. Stephen Lim is an experienced arbitrator and advocate who regularly appears as lead counsel before courts and tribunals in Singapore, where he is based, and overseas. Stephen has extensive experience with disputes across Asia Pacific, covering a broad and impressive range of disciplines, and is considered one of the leading advocates in the region. And these are not just my words. Stephen has received recognition as, quote, a prominent counsel in arbitration and a, quote, very impressive advocate in Chambers Legal 500 and in other legal publications. Our panelists today are Kelvin Chong, Nathan Zhou, Yanhua Lin, and Weina Ye. Kelvin is a partner at PwC's Forensic Services practice based in Hong Kong. He specializes in large and complex investigations into fraud, bribery, and corruption. Outside his investigations work, he regularly provides training for forensic professionals across Asia Pacific. Nathan is an associate in Clifford Chance's dispute resolution team in Shanghai. Nathan regularly advises clients in the PRC and overseas on arbitration and other forms of dispute resolution. Yanhua is a partner in Fangda Partners in Beijing. She specializes in dispute resolution, including litigation, arbitration, and regulatory investigations. She has represented clients in many complex disputes before arbitral institutions and also before the PRC courts at all levels. Weina is a partner in Herbert Smith Freehills and HSF's joint operation firm Ke Wei in Shanghai. Weina advises on cross-border commercial disputes and international arbitration. And finally, a brief introduction to the HK45 for those of you who may not be familiar with us. HK45 is affiliated with the HKIAC and promotes arbitration and provides opportunities for younger arbitration practitioners in Hong Kong and beyond to develop their skills. And this is, of course, exactly what we will be doing today. In today's training session, Stephen will be teaching us about effective advocacy, including cross-examination of witnesses. We have therefore assembled a fictional case study, and you will shortly be meeting the two brave volunteers who have agreed to act as witnesses for Stephen to cross-examine. The case study has been sent to you, but for those of you who have not had time to read it, I will provide a short introduction. Before I do so, however, I'm going to hand over to Stephen to give you an introduction about written and oral advocacy before we begin with the mock cross-examination. Over to you, Stephen.
Thank you very much, Ben, and thank you very much to HK45 for inviting me to participate in this training session. Before I begin talking about advocacy and why I'm talking about advocacy in international arbitration, I should say I realize that the words Essex and Chambers have become very, very famous in China over the last few days. And I should say that fortunately or unfortunately, I claim to have no part of this. since actually I'm with 39 Essex Chambers, which is a different chamber from Essex Court Chamber, which I'm sure many of you would have heard about in the news over the last few days. The reason why Essex appears in the name of my chamber and Essex Court Chamber is that English barristers are not known for being very imaginative, and they used to name the chambers after the location where they were. And 39 Essex used to be on 39 Essex Street, and Essex Court used to be on Essex Court, and that's why you have Essex. But I just thought I would make that short remark in case anyone was attending today to see whether there was any notoriety going on in today's session. Let me move on to talk about advocacy in international arbitration. The first thing I should say about this as well is that while my name is Stephen Lim, and while Singapore, my native country, considers Mandarin to be my mother tongue, in truth, English is my first language. I have to confess that, and I would struggle if I would have to advocate in Mandarin. So why am I, who is effectively a native English speaker, giving this session talking about advocacy for non-native English speakers? Well, one, I have practiced in Asia for all of my career, and increasingly, I have seen a good number of Asian firms and Asian practitioners appearing as counsel in international arbitrations. And I think it's a fantastic development. I've seen firms from China, from Korea, from Vietnam, and I certainly want to encourage that. And I want to encourage Asian practitioners, Chinese practitioners, Vietnamese practitioners, or Korean practitioners, or where else you may be from Asia, particularly if English is not your native language, to take up this mantle of actually taking on advocacy in English in international arbitration. We know that for the moment, English is the default language for international arbitration. Most international arbitration goes on in English. I know that increasingly for the Chinese market, you do get arbitration in Mandarin, where I would be on the other side of this conversation and trying to figure out how would I would advocate in Mandarin. But as an arbitrator, I have seen this development, and I've seen lawyers who are non-native speakers presenting, and I think it's perfectly feasible. And the fact that you may not speak with, you may speak with a slightly different accent, or you may not be that completely fluent, I don't think actually prevents the tribunal from understanding you. In fact, the tribunal, most of all, wants to understand you. But I should say also that, of course, we have with us Yan Hua and Weina, who will set me right if they think that what I'm saying doesn't make any sense at all. So, with that introduction, let me get on to talking about advocacy in international arbitration. I'll be talking first about written advocacy, and I'll make some comments about oral advocacy. And then after that, as I mentioned, Yan Hua and Weina will react to what I say and will tell me if what I'm saying doesn't make any sense at all and does not appreciate the reality of being a non-native English speaker advocating in English. I should also say that I'm not going to give you any special tips about how to advocate in English as a non-native speaker. What I'm going to talk to you about is how to present good advocacy in international arbitration generally. And why is this relevant for today's topic? It is relevant because what I'm going to say about good advocacy, I think, is achievable by anyone who is at least basically competent in English, even if it is not your native language. I mean, of course, I don't want to overstretch what I'm saying. I mean, you do need to have a certain level of competency. Like I wouldn't try and advocate in Mandarin simply because I do not have the vocabulary to try and arbitrate in Mandarin. But many of the practitioners who are non-native speakers who have appeared before me I think have sufficient vocabulary. I mean, I would say, look, if you have taken a university level course in English, which I'm sure many of you have, then I think you're perfectly capable, even if it is not your native language, of advocating effectively in English in international arbitration. And why do I say that? Well, I'll keep coming back in what I'm going to present on two things, which I think is what you need to strive for in advocacy. It is what arbitrators really hope for and want when they either read something you've written in your brief or your submission, or they're listening to you in your oral argument. And really two simple things. One is clarity and simplicity. That's what we want. We really want to understand what your case is, what the issues are. And what helps us to understand it, if you present your ideas, the points you want to make, as clearly as possible and as simply as possible. Now, when I say simply, I don't necessarily mean simplistic. I don't mean if you got a complicated case that you present it in a very simplistic way where you don't actually deal with the issues. You obviously have to deal with the issues, but the mark of a true advocate is someone who makes the most complex case simple, who breaks down the complex issues to simpler issues which the tribunal can understand easily and quickly. That's what is the most effective advocacy, whether it's written or oral or in international arbitration or anywhere else for that matter. So let me focus a little bit. I don't have much time. I mean, it's only 20 minutes to talk about advocacy, so I really don't have much time. I can give a really fleeting view of given from my experience, both as an advocate and also as an arbitrator. So focusing first on written advocacy, what should you try and aim for? What's effective? As I've said, clear, short sentences, I think, are the most effective way to write if you're putting a brief. And that's again why I say it is very achievable, even if English is not your native language, for you to write and present a brief. And I've read briefs written by Chinese practitioners or Vietnamese practitioners or Korean practitioners. And it's perfectly fine, so long as it's clear and short. And you don't need to, you don't need to write like you're a great novelist, and please don't think you have to use very complicated words or a very wide vocabulary. I think some years back, there was a real fixation of the first Prime Minister of Singapore, Lee Kuan Yew. Some of you may know about him, and he had a real issue about the use of English, particularly in the public service, but also within the country as a whole. And one of the things, he held various talks and seminars about it. And one of the things he said, and it's in a speech, I think you can find it online if you want to, is that he wanted all public servants, when they write any paper, to write it in a way so that somebody who was 12 years old, meaning you've had 6 years of primary education, could read it and understand it. So that's the kind of clarity and simplicity that I'm talking about. You don't need to write in a very complicated way. You can write, in fact, what you really want to aim to do is to write in as simple a way as possible. You may be dealing with very, very complex issues, but write it in as simple way as possible so anybody can understand it. When you read books on advocacy, and people talk about how you should prepare for it, because some of the advice given also is that you should try and present your case to somebody who is not a lawyer and see whether he can understand what your case is about. And that's a true mark of an advocate, because if you can present your case so that somebody who's not a lawyer can understand your case, then you're presenting it clearly and simply so that anybody can understand it. Now, the other thing that I want to stress about written advocacy is, please be as concise as possible. And by that, I mean, try and write your briefs or your submissions as briefly as possible to make the point that you want to make as clearly as possible. I'm not saying that there's a fixed page limit, that no brief should be more than 10 pages. Obviously, the context a complex case may require more than that, but what you're always aiming to achieve is to keep your submissions as brief as possible. This is one where more is not better. This is definitely one where less is best. Arbitrators are busy, and nobody wants to read 50 pages to try and understand a case if 25 pages will do. And that's something else I'd say. So again, if you're facing the challenge of writing a brief, and English is not your native language, and the other side may produce 100 pages, please don't think you have to produce 100 pages. If you can say what you need to say in 25, the tribunal will be very, very grateful to you. And the prolix party on the other side that's written 100 pages, will not necessarily get an edge on you. In fact, you may irritate the tribunal if the tribunal has to read a lot of prolix language before they really understand the case. The other point I want to leave with you about written advocacy is, don't dilute your arguments. And I've seen this with the best lawyers, the best firms. Some people think that they have to run all the arguments they can think of on that case. And the difficulty with that is if you run too many arguments, some of which are necessarily conflicting, don't necessarily fit together, the tribunal won't know at the end of the day what case you're actually running. I think you've got to be very clear, and this is something, again, which is not a matter of language. It's a matter of your skill as a lawyer. You need to figure out what is the best case you have. And that's the case you need to run. That's the case you need to push. If you have to run an alternative case, by all means do. I mean, I would personally try and keep it to one alternative case at best. But at least it's clear to the tribunal what you're actually advocating. Because remember, advocacy ultimately is persuasion. You're trying to persuade the tribunal why they should find in your favor and not in the other side's favor. And if you don't give the tribunal a clear and convincing case why they should go with one route rather than the other, the tribunal will have some difficulty in being persuaded by you. They'll be confused by actually what you're trying to push. Well, let me move on, because I see I'm pushing up already against the time that I have. I just wanted to mention very, very quickly that one thing that I've been doing recently is I've been reading a book about more effective writing, and it doesn't have a title which jumps out at you. And when I looked at the title, it didn't look that interesting, but actually I think it's a fantastic book. And the title is Thinking Like a Writer, A Lawyer's Guide to Effective Writing and Editing. So I said, when I looked at the title, it didn't jump out at me, but I found it extremely helpful. Even though I've been practicing more than 25 years, I've been learning from this, because what the focus is on this book is not about what language you should use. It's about your language ability, particularly in English. This is written for the American market. But what they are really looking at is how you can actually organize your material and to make it as clear. They use the word super clarity, that if you organize your material this way, it would make it easy for anybody to understand it. And I'll just very, very briefly run through to you what those principles are. I mean, the first principle they have is that readers absorb information best if they understand the significance as soon as they see it. And therefore, what the advice is, if you're going to present an argument, present the significance of that argument or the information you're going to put down to the issue that you need to decide in the context of arbitration, to what's the issue before the tribunal. Tell them that what I'm going to talk about now is about this issue, which is an issue that you do need to decide. And once the tribunal has got his head around, okay, this is what you're talking about, they can better understand the information, the flow of the logic that you're presenting to them. The second principle they advocate is that readers absorb information best if its form, so the structure and sequence of your writing, mirrors the substance, mirrors the logic of the analysis, the logic of the argument, or the plot of the story that you're trying to present. So again, it's all this is talking about how you organize things, and not about your fluency with the language. And what the point I'm bringing across is, you can use advice like this, even if you're not, if you feel that you're not that fluent in English, you can use advice like this to present your material in a way that makes it easier for whoever's reading it to understand it. Just two more principles before I move on, which is one, readers absorb information best if they absorb it in pieces. So again, please liberally use paragraphs. I mean, I generally always, when I write, use at least a minimum 1.5 points and have white spacing between paragraphs, because that's a much easier way for someone to absorb information off the page rather than a single space, dense paragraphs. When I look at a submission that comes in that form, my heart sinks straight away, because it's just harder for me to read it than if it was just clearly presented. I mean, this is one case where saving trees may not necessarily be the aim, but anyway, we're moving to electronic documents, so it doesn't matter how much white space you have in your documents. We're not necessarily going to cut down any more trees for that. And the final principle is one that you should try to remember, which is readers pay more attention if you approach your material from their perspective. And the point there being, if you're writing to a tribunal, what does the tribunal want ultimately? When they read your arguments, when they listen to you, they want to understand, what you say that will help them write their award. That's ultimately what they want. So if you structure your submission so that you are helping them write the award, if they can actually take what you write and cut that out and paste it into their award, then you quickly make a friend of the arbitrator. Then not. But I realize I've been talking about written advocacy, and I haven't gone into oral advocacy, but it's very similar. Everything that I've said about written advocacy applies to oral advocacy. I mean, one is it's the organization, the clarity and simplicity, they don't change. What you say, what you write, should flow into what you say. But there are a few things which I want to stress about oral advocacy. So by the time you get to oral advocacy, basically in international arbitration, tribunal would have read all the real written material. If they are a tribunal worth their salt, meaning if they've done their work and they've read the material before coming to the hearing, they'll know quite a bit of your arguments already. So when it comes to the oral part of the submission, this is where you really need to be laser sharp. This is where you really need to try and hone on to the real issues. You need to get to the core of the issue and get there pretty quickly as well. So that will hold the tribunal's attention. They already know the case, and they probably already have some ideas in the mind about what issues they want to hear. And if you get to the issues that they're interested in quickly, then you're going to hold their attention. The same points apply still about being clear, concise, use simple words. You don't need to have very flowery language when you're presenting orally. That I've heard some advocates who speak perfect English, they're native speakers, but they speak in a way in which is not clear and concise. And I don't understand. I find great difficulty following what they're saying is perfectly good English, but I just don't get the point. Because they are not trying to be clear, they're not trying to be concise, they're not using simple words. They're not trying to take all the advice that I given earlier about trying to focus on a point and guide the tribunal through the issue. And again, I'll repeat some of the things I said. Be very clear about your case theory. Be extremely clear about your case theory, and push your case theory in your oral advocacy. This is your one opportunity to push your case theory before the tribunal, and that's what you should be doing. Another thing about oral advocacy is this is where it's different from written advocacy. You have to be flexible, because this is the best thing about oral advocacy. And I believe in oral advocacy. I think it's an important place in international arbitration, which allows a dialogue between the tribunal and the counsel. As I said, if the tribunal's done their work, when they've got to the hearing room, they will know already most of the issues in the case. They will have questions and thoughts and ideas about the case, and they will want to put it to you. They'll want to challenge you with that. They'll want you to answer the questions and the doubts they have in your mind. So it is a dialogue. Don't go into an oral argument thinking that you're going to be able to, to have the lectern and you're going to speak uninterrupted for whatever time that you've been allotted. I think the best oral argument you would have is where the tribunal is engaged and they're engaging with you and you are engaging back. But in order for you to be able to do that, you have to be flexible. You have to know your case so well that you can move from point to point very quickly if the tribunal moves in that direction. And that brings me to one point, which I did say I would talk about, which is the use of PowerPoint presentations. I know it gets used a lot in international arbitration. I've seen it used a lot, and it's also used by lawyers who are native speakers. I've seen that. I don't tend to do it myself. I've said I'm a bit old school that way, because when I started practice, we didn't have PowerPoint, and I believe in having a skeleton argument, which could be somewhat similar. I mean, it's basically your points on a piece of paper, which you will hand up to the tribunal so they can follow you as well. But I think the difference here is, and this is why I raised it on flexibility, because if you've got it on a piece of paper, you are much more flexible. You can move around it very quickly, because the tribunal wants to move a different point. You can just quickly move, and you can tell the tribunal either just move off and leave the skeleton for a moment while you deal with the issue, or you tell the tribunal, I'm moving on, and you can see my point on that. You want to follow me on page whatever. It's so much harder for you to do that if you're on a PowerPoint. You'd be flipping, and it may not be that easy for you to move it. The other thing about PowerPoint, in my point of view, would be if you've got it up, it's usually on the other side of the room from where the arbitrator is, because you'll have it facing the arbitrator. So the arbitrator will be looking at the PowerPoint. You might be looking at the PowerPoint as well, because you're looking at the PowerPoint to make sure that you're presenting it. And you're not looking at the arbitrator, and that contact with the arbitrator, looking at the arbitrator, seeing whether he's following you, I think is really important as well. So, I mean, I'm not saying don't use PowerPoint. If it makes you feel more comfortable, by all means, do use the PowerPoint, but use it judiciously, and maybe think about using, a skeleton argument as opposed to a PowerPoint. You can put almost the same thing you want on that piece of paper, but just hand out the piece of paper rather than put it on a big screen facing the arbitrator. So I think I've spoken probably longer than I should have on this issue. So let me pause here and hear Weina's and Yanhua's reactions to what I've said. Does it make sense for a non-native English speaker, or do you think I do not appreciate fully the challenges that you face? I can't hear Weina. Am I the only one that can't hear Weina? You're on mute now.
Sorry, can you hear me now?
Yeah, great.
Yes. Oh, okay, sorry. Yeah, it's the headset issue. I think perhaps I'll have a go first, and just to sort of respond a little bit, and also share my own experiences as well as my pains, I have to say, in making doing advocacy in international arbitration cases. First of all, I'd agree, and I think the points that Stephen has made are all very good points in terms of sort of doing advocacy in international arbitration cases. I have to say, because I think Yanhua will, a lot of us will have a lot of experience doing advocacy as well in our native language, for example, in Mandarin Chinese, and all these skills are transferable. In addition to what you need to pay attention is to sort of the language aspect of doing advocacy, or many other skills are actually quite transferable. For example, what Stephen said, you have to be concise, you need to simplify your case theory. I think it doesn't matter whether you're speaking in English or in Chinese, those sort of tips will apply nonetheless. And so I can't agree more on many of the points. I just have to sort of, I prepared some points about my own experience as a non-native speaker to do advocacy in a language that I am not entirely familiar with. So I think what I'll do is I share some of the difficulties that I had in that process, and then I'll share some of the tips that I think that we all need to be sort of aware of in order to overcome those difficulties. I just introduce myself a little bit in terms of sort of a language background. Mandarin Chinese is my native language. I was sort of educated in mainland China, and then I went to the UK when I was sort of 20 something. And so, it definitely is not a language that I started speaking to when I was young. And I had to spend sort of a couple of years to get used to that English speaking working language when I was first in the UK. So that was sort of my language background. In terms of professional background myself, I've been with Her Business Freehills all of my time, and I then transferred to sort of Kewei, the joint operation platform about a year ago. What that means to me is that I think, even if I have been practicing international arbitration for a very long time with a large firm like Her Business Freehills, which has a lot of very good advocates, we have a lot of a number of in-house QCs. I guess for the ones who speak English as a native language, they don't even have as many opportunities to do advocacy in big cases. And so for us, non-native speakers, I didn't think that we had as many opportunities to do this. But I think as just to respond to what Stephen said, I think we are at a time where we see a lot of cases coming from this region. And so, there's many cases coming from this Chinese market. And as we get more and more senior, and then you gradually get some opportunities of doing advocate. So for myself, I've done in English proceedings and bilingual proceedings, I've been acting second year in those cases. And I think it was fortunate that I sort of made the transfer to a Chinese firm last year. So I get the opportunity to do some Chinese proceedings as well as the advocacy in those cases. So all of that is quite helpful to myself. And I think I have to say, Stephen has shared quite a number of sort of tips, which I think is actually quite advanced. For a non-native speaker, when I was at very young or junior ages, what I found difficult was that not to talk about those sort of tips of doing advocacy as a non-native speaker. First of all, you have to get through the hurdle of sort of fully engaged in your case. And sometimes you feel that because of the language barrier, it is not even very easy to sort of fully follow what the case is about. You hear what the other side's witness say, you hear what the experts say, you hear what the other side's counsel say, but it requires a lot of sort of brain power to process the information, to sort of understand what the implications are of those things, and then react, very effectively, and then present your own case. So it's like a quite advanced, to me, when I was very junior, quite advanced exercise. It requires a lot of brain power of doing that. So that was very difficult to me when I was at a junior age. And then, in terms of language wise, I think one of the things that I found as a non-native speaker is, I think for me, it is a lot easier for me to convey my message in a clear and concise way when I speak Chinese. I don't know if this is true for a lot of sort of audience today, because when I speak English, sometimes I feel like I say a lot of words. I say, to make one point, I may need 5 sentences to get to that point. So you can't really make it. I know Stephen has just said it's very important that you say things in a very concise way. Actually, it's not very, very easy for a non-native speaker. Sometimes you hit around the bush all the time, but you can't really get to the point very easily for a non-native speaker. And so I think, in relation to those, it's often that you have nervousness, in the middle of the hearings, and when you present in front of very senior arbitrators, very senior counsel. That's all sort of something that we commonly seen or commonly encounter as non-native speakers. For myself, I think I just want to share a few points. First of all, preparation, I think, is very, very crucial to me. Stephen has just mentioned that as well. For myself, I think maybe over 95% of the work for the hearing will be done outside the hearing. Actually, you need to do a lot of preparation work. You review your case files. You have to be very familiar with the documents. You have to consider and test your case theory, decide what your case will be. You'll know what the key documents that you want to show to the tribunal at the hearing. You will know, what are the points that you will need to score from your own witnesses as well as the other side's witnesses, and you will know what your strength is, what the strength of your case is, and what the weaknesses of your cases. And all those work will have to be done before the hearing, and you need to sort of think it through very, very carefully. And it only when you have done all those work and when you are very familiar with your case, then you can sit and sort of in front of the tribunal with confidence, because you feel that you know the case better than anyone else in front, either, in the room, or the ones that you see in the screen. And when you get to that point that you feel like you know every detail of your case, then you have a lot more confidence as a native speaker. Then you don't have to, in terms of the issues that I had when I was junior, that you feel that you're not having enough brain power to process information. I think that issue will be resolved quite naturally, because whatever you hear from the other side or the witness, you'll be able to process it very instinctively, because you know case that well that you will know what it means. So I think preparation is absolutely critical for me in terms of doing oral advocacy. And Stephen, I think, just mentioned one thing as well. I think that's very important to myself too. That is, preparation is not only about prepping your own case, it's also about anticipating what the other sides will say and what the questions that the tribunal will have. So you need to sort of step out of your case and step into the shoes of the other sides and see what the strength will be for their case and the witnesses will be for their case. And then you will sort of stand in the middle and pretend that you are the tribunal members, and perhaps what type of questions that you will want to ask either party at the hearing. And those are very important, because as Stephen said, as a non-native speaker, you can prep your opening script, but you can't always prep for every question that the tribunal will have for you, right? But if you have thought that through, you have thought through your case theory, you have thought through every details of your case, then it'll be a lot easier for you, and it will help to sort of overcome your nervousness as well, because you sort of know what the tribunal will ask you during the opening. And the third point for me, I think, as a non-native speaker, it's very important to find your own style as well. That means a number of things, you know, whether you want to sort of use PPT, whether you want to use skeleton arguments, whether you want to prepare your own opening script, and etc. And for me, I think what worked is I like setting out my structure very well in front of a tribunal, and then I like using signposts during the sort of oral presentation. That's actually because, as Stephen has just said already, because you need to organize your materials and organize your arguments for the tribunal. But for me, I think, you know, it's also helpful every time when I use a signpost, it sort of tells myself that you know, this is my case. I'm in control. I'm still in control of my own case. So that is helpful for myself to use that type of thing. I think PPT is the same thing to me. I don't suggest putting a lot of content or making very full presentation slides, but to use certain sort of very brief level of arguments, or use to include certain signposts was helpful to myself in terms of making oral advocacy. Final point is to sort of, I think Stephen touched upon this as well, is to avoid irrelevant points or unreasonable points in a Chinese context. I don't know if it's sort of specific to Chinese clients, but I've had that quite often in practice. Sometimes the client wants you to say something, but it's not necessarily helpful for your case. And because the client is coming from a different perspective, maybe they have their sort of a commercial perspective. There's something else that they want to emphasize to the tribunal, but that's not necessarily helpful for your case. It might dilute your case, or it might sort of make your argument sort of internally not inconsistent sometimes. And so you need to resist that temptation of saying everything that your client wants you to say. And also sometimes you need to bear in mind the cultural aspect of presenting a case. Sometimes the client might feel that this is very appealing to a Chinese audience or Chinese arbitrator, but that might not necessarily be appealing to an arbitrator from a Western background. So sometimes your client tells you, this is the practice in China, and it's common practice, but you might not want to tell that to your arbitrator because they may find it not very appealing. So you will want to structure an argument from a different perspective. For example, you can say that, this is a relevant issue. So I think I've taken too much time to say this, so I'll pause there.
Thanks, Wayne. Perhaps we could hear just briefly from Yanhua, if possible. We're just slightly overrunning, Yanhua, so perhaps you could just keep it to a couple of minutes, if possible, please.
Yeah, sure. Thank you. Hello, this is Yanhua. Because in my entire career up to now, the primarily time I work with a Chinese law firm. I do have some experience, a few years working with the UK firm and the US firm. I have a sort of reaction to what Steve just said. Steve, you mentioned that in international arbitration, that the default language is English. I want to say that from my observation in recent years, it may not exactly the case in the Greater China area, because we already have an increasing number of international arbitration using Chinese language or English-Chinese bilingual language. And in those cases, many of them are still governed by English law or Hong Kong law. So in those cases, we actually work very frequently with like Steve or other barrister with a common law background. Many of them are in Hong Kong or in Singapore, and their native language is not Mandarin, right? But they're required to do the advocacy in Mandarin. But even with accent, we have no doubt that they can do good advocacy, right? So I think the same logic work in the same way when our non-native speakers required to do English advocacy. So I agree with Steve just said. I think my takeaway is that for advocacy, the primary issue is not language. It's always about your legal thinking, the understanding of the facts, your case theory. So as long as you can have a full and good understanding of your case theories, you would be able to do good advocacy, given that you have the sufficient vocabulary, right? So, and I also agree with Weena that, of course, there are challenges we have to face as non-native speakers. We need to do more preparation work. I think primarily because when we do trial, we are given limited time, right? So as the non-native speakers, we probably would think slower than we are thinking in our native language. So we have to do more preparation work. But the reality is, if like in most cases, I have been involved either when I was working with international firm, or when I am working in my own law firm. The reason why a Chinese person would be required to work in a case, in most cases, because there has to be a Chinese element involved, right? So you would have your advantage, either because you understand the witness, or because there are a lot of written documentations in Chinese. So you had an advantage to use your native language to help you to understand the case better. Even if in the trial, the language is not your native language, you must have some advantage to be involved in the case. So I think sometimes psychologically speaking, we'll be less confident when we are required to do English trial. But I think as long as we understand that English is not or language is not the primary issue, I think we have the courage to the courage or the advantage to face all the challenge and solve it. Yeah, that's all I would like to say for now.
That's very helpful, Yanhua. Stephen, unless you've got any response, shall I lead now to give a brief overview of your cross-examination presentation?
I think, but I'll save the response for later if we have time, because I know we're pressed against time. So I think you should get on with your summary of the case material. Sure.
Well, Chloe, could I ask you to bring the slides back up? Fantastic. So thanks to Stephen, Yanhua, and Weina there for the introduction into the setting the issues in its context. As I mentioned at the start, we have assembled a fictional case study with volunteers who have agreed to act as witnesses for Stephen to cross-examine. And the case study has been sent to you, but for those who have not had time to read it, I'll provide a very short introduction. In our fictional case study, a dispute has arisen during the construction of a nuclear power plant in Dalian between WUKE Limited Company, a Chinese company, as the employer, and Texas Construction Corporation, or TCC, which is a US-based construction company, as the contractor. The contract is governed by Chinese law and provides for all disputes to be referred to arbitration. Next slide, please. There was no agreement between the parties in the contract as to the timetable for the project, particularly the date on which the construction works were to be completed. WUKE alleges that TCC said it would complete the work by January 2017, and as it turned out, completion was delayed until 9th of August 2017. WUKE alleged that TCC was responsible for the delays because it did not have the necessary plant component parts fabricated and ready to be shipped in time, despite representing to WUKE that it did. TCC denies that it gave any such representation regarding the parts and said it never agreed to complete the work by January 2017. As I mentioned before, the contract doesn't set out what the timetable should be. Next slide, please. WUKE commenced arbitration against TCC, seeking recovery of penalties it had to pay to the State Grid Corporation of China for the delay. You'll remember this is a nuclear power plant, so therefore intended to generate electricity. WUKE also sought a declaration that they were entitled to rescind or terminate the contract as a result of TCC's misrepresentations concerning its ability to complete the work by January 2017 on the basis that the necessary parts could be shipped. TCC brought a counterclaim against WUKE for non-payment of certain sums due to them as per the contract. Next slide, please. The claimant's witnesses due to be cross-examined at the evidentiary hearing are Wei-He Tang, WUKE's Director of Operations, and Dr. Lei He, WUKE's CEO. Wei-He is a maths graduate from Lomonosov University in the then Soviet Union. In 2000, he obtained a JD degree from Harvard Law School. He was asked to take the job as Director of Operations at WUKE because the owner of the W Group, which sits above WUKE, needed someone who he could trust. Dr. He, the new CEO, had not previously worked with the group. Next slide, please. Dr. Lei He is an engineering graduate, also from Lomonosov University. She studied for an MS in engineering at MIT in the late 90s and then studied for a PhD in nuclear engineering. She was hired by Halliburton in early 2003 and worked on nuclear projects around the world. Next slide, please. The respondent will be calling Harry Yan, TCC's Director of Project Development, and John Hornblower, TCC's CEO. Harry Yan has a BS in engineering from Caltech and an MS in engineering from MIT. He was at MIT at the same time as Dr. He, and the two briefly dated. Harry has worked for Fluor and McDermott as a senior project engineering positions around the world. Harry left China with his parents when he was 9 and grew up in California. He has always been curious about his former homeland. And finally, John Hornblower, and I'll leave you guys to read his summary. So I'm going to pass over right now to Stephen. So I hope that introduction was helpful.
Thank you very much, Ben. So we will then move to cross-examination of the witnesses. Let me just set the scene slightly for those of you who are not too familiar with how examination of witnesses goes in international arbitration. The witness will be cross-examining witnesses for WUKE. I think just to make it simple, I'm going to refer it to as WUKE rather than WUKE. So counsel for WUKE would call the witnesses. They would ask them to, they may take the affirmation of the oath if necessary. They will ask them to confirm the evidence that's been given, which would be in the form of a witness statement. And then they would hand the witness over and say, the witness is my witness for cross-examination. So that's where we're going to pick it up from. And we're going to start with the cross-examination of Wei-He Tang. So I will begin the demonstration now. Good afternoon, Mr. Tang.
Good afternoon, Mr. Lin.
And I am counsel for TCC, and I have a few questions for you this afternoon about the evidence that you have given in your witness statement. Let me just try and begin with confirming some of the information of your background. The questions I'll put to you will generally be short questions and would usually only require a simple answer, yes or no. So, if you don't understand a question, please do let me know, and I will repeat the question for you. So let me begin, first of all, with a little bit about your background with WUKE. You are the Director of Operations for WUKE?
Yes, that's correct.
And you have been employed by WUKE for approximately 2 years?
Yes, that's right.
And prior to that, you were the General Counsel of W Group?
That's right.
And you have a law degree from Harvard Law School?
Yes.
Prior to joining WUKE, am I right you had no experience in the nuclear power industry?
Personally, I don't.
And it goes with that, I would assume, that you have no experience with the construction of nuclear power plants.
That's right.
Let me move on with a question about the terms of the PPA that WUKE entered into with SGCC, the State Grid Corporation. The PPA with SGCC contains a firm specification that the plant had to be completed and commissioned by early February 2017 at the latest. Is that correct?
And that's correct. And I want to add that if this is a very important clause, and if we don't meet that timeline, we'll be subject to a serious penalty.
Thank you, Mr. Tang. We'll come back to this point later. I'm going to move on with some questions about how you got TCC involved in this case. I believe you first approached TCC on this project in or around July of 2015.
That's right.
Now, how did you first contact TCC?
I don't remember. It could be.
Well, let me help you with your memory there. Was it by telephone?
Possibly.
Do you remember telephoning Harry Yan in late July of 2015?
At the time, we were looking for service providers. So I was the one calling them one by one. So possibly that I was the one who telephoned Harry.
Right. Well, I believe you would have had the witness statement of Mr. Harry Yan available to you. And let me read out what he says in his witness statement at paragraph 2. He says, in late July 2015, I received a call from Wei-He Tang, who introduced himself as a director of operations at WUKE. I had never dealt with Wei-He before, but I assume he had been recommended by his colleagues to get in touch with me. Do you have any reason to believe that this conversation did not occur?
I think our conversation did occur. Harry's contact is referred to me by our CEO.
Right. Thank you. let me ask you a little bit about the project lead time. You made a point earlier about the importance of the timeline for completion. The typical lead time for such a project of this nature, for constructing this power plant, is approximately 16 to 20 months. Is that right?
Yes.
And can I ask you, since you had no experience with nuclear power plant construction, how do you know that that is the approximate lead time?
Well, as I mentioned earlier, I spoke to a number of service providers at the time. So not just Harry, but some other potential candidates as well. And based on what I've learned from those conversations, I would say 16, 20 months is sort of the average time that I've learned from those discussions.
Yes, indeed, Mr. Tang. In fact, didn't Harry Yan himself tell you in the first conversation that you had in July of 2015 that the typical lead time for such projects is 18 to 20 months?
I don't remember exactly the range that he told me at the time. I think 20 months is probably the right sort of the upper end of that range. But I guess it doesn't matter because TCC said to us that they can complete in 12 months.
Well, I've taken you already to the witness statement of Mr. Yan. Let me take you again to the witness statement of Mr. Yan at paragraph 3. He's talking about the conversation he had with you in July of 2015. And he says, you will see from the second line onwards of the paragraph, I remarked that completing the plant within 20 months should in theory be doable, since the typical lead time for such projects is 18 to 20 months. So that's what Mr. Yan says he told you when you had that conversation.
Well, okay, if that's what he said, but as I mentioned, I spoke to a number of candidates at the time, so I must have learned from some other providers that 16 months could be possible too.
Well, I think what's important here is what Mr. Yan said to you. But let's move on. I'm going to ask you some questions about the pictures of ready fabricated components, which forms an important part of this case. You say in your witness statement that you sent an email to Harry Yan on Friday, 4th of January, 2016, asking for copies of engineering drawings and pictures of ready fabricated components. Is that right?
Yep, I did send such an email.
I just want to check the date with you. Are you sure it was Friday, 4th of January, 2016?
Yeah, it should be around that time.
Well, I did check the calendar, and the 4th of January, 2016 is actually a Monday. Perhaps to help you with your memory, we have in the bundle of documents, Exhibit A, which is the correspondence, the email correspondence you had with Harry Yan. And we can see from that, and I invite you to take a look at that too, that your email was sent to Harry Yan on Sunday, January 3rd of 2016. Do you agree with that?
Okay, so I have that email in front of me. So, it says Sunday, the 3rd of January, 2016. So if this is what the email says, then I guess that's the date I actually email Harry.
All right, thank you. So I would be fair to say then that what you said in your witness statement about the date is not correct.
Yeah, if this is what the email suggests. I guess at the time, there was the sort of intense period where we at the final stage of the contract negotiation, so I could have mixed up the date.
That's fine, Mr. Tang. I just want to make sure I get the facts right. Now, I have another question for you about that email. You say in your witness statement, and this is at paragraph 9 of your witness statement, that you ended the email by making the point that all of these documents should be provided at or before the meeting taking place the following week in Houston. Do you see that in your witness statement?
Yep.
Now, if I could ask you to turn back to Exhibit A and your email to Mr. Yan, you would see your very first sentence. It begins, "Dear Harry, please could you ensure that you provide at or prior to the meeting taking place in Houston next Tuesday," and you list the documents that you want. So, in fact, you began the email by asking for this, didn't you?
Looking at the email again, yes, I did mention it at the beginning, but it doesn't really matter. I mean, the most important thing is I did make the point.
Well, I just want to make sure that we get the facts right. And I want to make sure also that we understand exactly what your evidence is. So I think, again, it's correct to say that your witness statement is not accurate on this point.
Well, in terms of the precision of where I put that statement on the email, yes, that's not correct. But again, I did make the point on that email.
Well, that's all I needed to establish. Thank you. So let's move on then. One of the points you made earlier in your evidence was what TCC allegedly represented to you about the time in which the project could be completed. You will say in your witness statement, and this is at paragraph 6 of your witness statement, that sometime in October, Harry Yan assured you over the phone that TCC could complete the project in good time.
Yep.
Right. So that is a yes, you agree with that.
Yep.
And more specifically, you say again in paragraph 6, that if the contract was signed by January 2016, he was confident of completing the plant within 12 months because TCC had many of the major nuclear power plants, including some components of the cooling rods already fabricated and ready to ship.
That's correct.
Now, you say you had this conversation. Do you remember the date in October when this telephone conversation took place?
I don't remember the exact date, but it's likely to be in the 2nd or the 3rd week of October. I mean, the reason I say that is, not sure if you know, Mr. Nim, in China, we do have national holidays in the 1st week of October. So it's likely to be sort of the week after, the 1st work week after the holidays.
Well, let me help you with your memory here. Again, if I could ask you to turn to Exhibit A. And as part of Exhibit A, there's another exchange of emails, which is between yourself and Harry Yan on the 18th of October, 2015. I'll give you a moment to take a look at that to refresh your memory. Please let me know when you have read it.
Okay, I just got the email in front of me.
Right, so this email, well, your email begins with, to Mr. Yan, are you able to give us a firm indication of when the project can be completed? And you said, I've asked you this before, but you have to this date not sent me the relevant information. Please do so without any further delay, as time is of the essence. So now that you've seen this email, isn't it correct that your question was put to Mr. Yan in an email and not in a conversation?
Not necessarily, Mr. Lim. I mean, yes, the email exists and was sent in 18th of October, but quite possibly we could have a phone conversation prior to that.
Yes, because you do say, I have asked you this before, but you have not sent me the relevant information. So he did not tell you, he did not represent to you prior to this what the completion date would be. Isn't that correct?
I guess so. I guess in our in our conversation prior to that email, he wasn't clear on when exactly the project can be completed. That's why I pressed on asking this question on a follow-up email.
That's right. That's why you sent him this email. So let's look at what Mr. Yan said in reply to your email. Right? He said, "Hello, Mr. Tang. It goes without saying that using the diverted plant components will speed things up considerably. I cannot be definitive, but based on what you've told me, I think we'll be able to meet your demands." So Mr. Yan specifically said, I cannot be definitive. Do you agree with that?
Well, he mentioned that on his email, but he also mentioned on the email that I think we'll be able to meet your demands.
Right, but it's prefaced by the words, I cannot be definitive. That's what Harry Yan told you.
Well, I mean, I've seen many of these types of emails in my day job, and people like service provider, they always like to put some sort of language, like a disclaimer language to protect themselves, right? So I won't be surprised if this sort of words was used on the email, but the most important thing he did mention on the email is we'll be able to meet your demands.
Well, with the disclaimer, Mr. Tang, as using your own words, with the disclaimer. But let's move on. So you asked Mr. Yan for some pictures for ready fabricated components, and specifically, and again, we can go back to the earlier email exchange in Exhibit A, that you asked for engineering drawings for the proposed nuclear power plant and photographs of some components of the cooling rods that are ready to ship. Do you see that in your email to Mr. Yan?
Yes.
And that's all you asked for, is that correct?
Yeah, based on the email, yes.
Now, you didn't tell Harry Yan why you wanted these documents, did you?
Not on the email specifically, but I mean, as I mentioned, there were numerous telephone conversations leading to that email, and especially to that meeting with our CEO. So, I mean, it must be obvious to him that why I'm asking these documents.
Well, that's what you also say in your witness statement, Mr. Tang, at paragraph 9. You say expressly, although I did not say this expressly in my email, it was obvious. You say it was obvious that we were asking for the pictures in order to assess the credibility of Harry's claim that TCC could complete the project within 12 months. Well, let's see what Harry Yan says in relation to that. As I'm sure you would have read his witness statement, and you will see at paragraph 6, what he says is, I did not understand why he, meaning you, Mr. Tang, needed these pictures. And he has his own view of this. He says it was obvious to anybody in the industry that those nuclear power plant parks would have to be modified in order to suit the conditions in Dalian, China. So you had one assumption in your mind, Mr. Tang, but Mr. Yan had another assumption. Well, I want to establish one fact, though, which I think we have, but let me just try and be clear about this. In that email, you didn't tell Harry Yan that the pictures were to assess the credibility of his claim that TCC could complete the project in 12 months.
Sorry, which email are you talking about now?
In the email exchange on the 3rd of January, 2016 at Exhibit A.
Well, again, the purpose of sending that email is to get him prepared those documents so that my CEO can review them in Houston.
Well, so the question I put to you was, you did ask for that, but you didn't say in that email that the reason you wanted this was to assess the credibility of Harry Yan's claim, as you say, that TCC could complete the project in 12 months.
Yes, not black and white on the email, but I'm sure he knows.
We've already looked at that point, Mr. Tang, about the different assumptions that you and Mr. Yan had. Let me move on to another point about the completion date of the construction, which you said was an important point. The contract you had with TCC did not provide for a construction timetable.
Correct.
So the contract did not provide for any completion date.
That's correct.
So we've established, Mr. Tang, that you are a Harvard-trained lawyer. You were general counsel of W Group before taking on your current role.
That's correct.
Yes. So as a lawyer, if you wanted the project completed by a certain date, wouldn't you agree it is important to include that as a contractual term?
I agree it's important to include the timetable on the contract. However, I was not tasked with the contract drafting for that project, nor I was the GC for Wuke.
Well, Mr. Tang, you were in charge of negotiating this project with TCC right up till the point where your CEO went to Houston. Yes?
That's right.
And I think you've also made the point that it was very important. You asked for the photographs of those components because you thought establishing that fact was very important. Yes?
Yes.
And in fact, before your CEO went to Houston, or while your CEO was in Houston, I believe either of those points, you told your CEO that those photographs were very important and she had to take a look at them. Yes?
Correct.
So if a completion date for the project was also important, as you say, why didn't you raise that with the CEO to make sure that that was included in the contract?
Well, again, I agree that it's a miss. It should have been included in the contract. However, the drafting was done by Harry. I think he admitted that or agreed that in his witness statement. Then my CEO took over sort of the final stages of the negotiation. So again, looking back, the timetable should have included in the contract, but it's a miss.
Right. That's all that I have for you, Mr. Tang. Thank you very much. No further questions. So that brings that cross-examination to a close. I'm next going to cross-examine the CEO, Dr. He. Before I do that, I will talk about how I've structured this cross-examination later, but just want you to notice, if you haven't noted, I try and keep my questions short. Sometimes it's not possible because I have to quote either lengthy facts or lengthy excerpts from the witness statement. But I do try as much as possible to keep the question short. And of course, I try and avoid as much as possible a complex question, which is too many points within the question, because if you have that, then the witness doesn't know exactly what you're trying to ask him. So I just wanted to point that out, and I ask you to try and note that as I go through the cross-examination with Dr. He. So we will pick this up at the same point. Good afternoon, Dr. He.
Good afternoon, Mr. Lin.
Right, I have a few questions for you on the evidence you've given. I'd like to begin just to make sure I understand the role you play in this. So you are the CEO of WUKA?
Yes.
And prior to joining WUKA, you worked for Halliburton for 13 years on nuclear power plant projects around the world.
Correct.
And you are trained as an engineer at Lomonosov University.
Yes.
You have an MS in engineering from MIT.
Yes.
And a PhD in nuclear engineering from MIT.
Correct.
So you have considerable experience in the nuclear power industry.
I think so. That's correct.
And also with the construction of nuclear power plants.
I don't think so, because I compared with my counterparts on the other side. I have less knowledge in this regard, because as you have mentioned, nuclear engineering is a comprehensive subject involving too many different branches of science and technology. So I'm not an expert in this regard.
Well, we just established, Dr. He, that prior to joining WUKA, you worked for Halliburton, which is also a contractor, for 13 years on nuclear power plant projects around the world. So you have 13 years experience with nuclear power plant projects, and that stretches across the world.
I would like to draw an analogy in this regard. I played a role in Halliburton like an office manager in a law firm, but I am not an expert in a particular legal expertise, and I cannot provide legal advices to our clients. So my experience is focused on operation and management instead of construction.
Well, you mentioned legal expertise and legal advice, Dr. He. I didn't ask you about your legal expertise. I asked you about your experience with the construction of nuclear power plants. Well, let's take a look at your witness statement. At paragraph 4 of your witness statement, you said that you thought it was a good idea for you to attend the meeting alone without Mr. Tang. And these are your words, since I knew a lot more about nuclear power plants than he did.
Yes, correct.
So it was your decision to attend the final negotiation meeting in Houston alone.
Yes.
And the reason you took that decision is because you were more familiar with nuclear, let me use your words again, you were more familiar with nuclear power plants than Mr. Tang was.
I think this is the first reason. Another reason is that I noticed that the dynamics between Wei He and Harry back then was not good. So I would like to work out a solution with the other side. And that's why I went to Houston alone without Wei He's company.
Right, so you wanted to make sure that you close this deal.
I want this deal to work out because we attached great importance on this.
Right, let's move on. Let me ask you about some photographs that you were given when you went to the meeting in Houston. You said that Harry Yan gave you an envelope containing pictures at the beginning of the Houston meeting.
Yes.
And he said these contained pictures which Wei He had asked for.
Yes.
Now, you also say he didn't say anything else to you about the pictures, and then Harry left the meeting room.
He just mentioned that those are the photos as requested by Wei He before the meeting. Yeah.
Yes, and then he left the meeting room.
Yes.
And you say you spent about 15 minutes looking at the photographs on your own.
That's correct. About 15 minutes.
Like you said, Harry left the room to grab a file.
That's correct.
And John Hornblower was talking on his cell phone during the time that Harry was out of the room.
That's correct.
And you say that when Harry returned to the room, you put the photographs back in the envelope.
Yes.
So you didn't discuss these photographs with either Harry Yan or John Hornblower, did you?
No, I didn't. The reason is that because before I entering into the meeting room with Harry and John, and before I review these photos, I have an impression that in an email, I was also copied between Lei He and Wei He, between Wei He and Harry. Wei He expressly mentioned that he needs some photos to demonstrate the cooling rods are ready to ship. So I have that impression and assumption before reviewing these photos.
Yeah, yes. Well, you mentioned an email that you were copied on. So I assume you are referring to an email sent by Wei He on Sunday, January 3rd, 2016, which is at Exhibit A of the documents we have in this arbitration.
Yes, this is the email I just referred to.
Yes. So the email says, addressed to Harry, as that please, could you ensure that you provide at or prior to the meeting taking place in Houston next Tuesday, engineering drawings for the proposed nuclear power plant, photographs of some components of the cooling rods that are ready to ship. That is all that the email says.
Yes.
Yes? All right. Now, I just want to be clear about the facts of what happened at that meeting. So we've seen Wei He had sent this email simply asking for these documents, for these photographs, the engineering drawings and the photographs.
Yes, he asked for those photos. Yeah.
And that's all it says in the email. Just let us have these documents, these drawings and these photographs. You arrive in Houston. You are given the envelope which contain these drawings and photographs by Harry Yan. Harry Yan tells you this is what Wei He asked for. He doesn't say anything else. He leaves the room. John Hornblower is talking on his cell phone. When Harry comes back, you put the photographs back in the envelope. Then you proceeded with the meeting. Yes?
Yes.
So neither Harry nor John said anything to you about the photographs, aside from the fact that Harry had given them to you as the pictures that Wei He had asked for.
No, we didn't further explore those photos, but as I had just mentioned, I entered the negotiation with the other side with the assumption that those are the photos we need, and Wei He mentioned in his email, those are components ready to ship.
Right, thank you for that, but I just want to be very clear about your answer, because the question was that neither Harry nor John said anything to you about the photographs, aside from handing them to you as the pictures that Wei He had asked for. So you had begun by saying no, but I think actually your answer to that specific question is yes.
Yes.
Thank you. And you didn't say anything to Harry or John about what you were looking for in the photographs.
No, we didn't further discuss these photos.
All right. Now, I want you to think carefully about this. You say you looked at the photographs for about 15 minutes. I'm suddenly getting an echo. Okay, it stopped. All right, we can continue. Now, you say you looked at the photographs for about 15 minutes. Now, it could have been less than 15 minutes, couldn't it?
Maybe.
You can't actually be sure how long you looked at the photographs, can you?
I think 15 minutes is an accurate reflection of what happened back then. But maybe 40 minutes, I cannot be 100% sure, but I think it's an accurate estimation.
All right, let's move on. Later that evening, you had a call with Wei He.
Yes.
And you said to Wei He, the pictures appeared to be of the nuclear power plant parts that were fabricated and ready to ship from Texas, and that they looked fine to you.
I did say that.
Yes, you said that, right? Yes, the answer is yes.
Yes.
And so that was your own conclusion after looking at the photographs.
That's my own conclusion, and I got such conclusion with the assumption I had just mentioned.
Yes, your assumption. And so your conclusion, your assumption was based on what you saw in the photographs.
And what Harry and Wei He said in their emails.
Right, which we have seen in their email, that email. You're referring to the email of 3rd of January 2016, yes?
Yeah, yes.
And we have seen that all it says is Wei He had asked, can you please provide these drawings and photographs at the meeting? And that is all that is said.
But Harry, in the immediate reply, said that please see below for your attention. So I understand that Harry didn't refuse such request.
Well, we know that because he gave the photographs to you.
Yes.
in Houston. The thing is that aside from giving the photographs to you, neither Harry Yan or John Blower said anything to you about those photographs.
They didn't say anything more about those photographs at the meeting.
Yes, thank you. Now, Wei He had told you in a telephone conversation earlier that morning of that meeting that the photographs were important.
Yes.
But you seem to have left those photographs in the meeting room in Houston.
Yes, because I was rushing to another dinner party, so I left those envelope and pictures in the office of TCC.
Well, you may have left them in a rush, but it seems you were no rush to get them back.
I did ask for those photographs to be couriered to me maybe 3 or 4 days later.
Yes, but when we can take a look at that, that's in an email of the 10th of January, which you sent to Mr. John Hornblower. This is Exhibit B in the documents, and you say, as a by the way remark, you say, by the way, I think I may have left the envelope you handed to me in your meeting room. I would be grateful if you could arrange it for it to be posted to me in Dalian, China. No rush is how you ended that request.
I did not rush for the return of those photographs for like 2 reasons. The first is that I have checked those photos on site in the office of TCC. So that's the first reason. The second reason is that, of course, those photos are important, but more important is the meaning behind those photos. Even I left those photos right behind me myself, but I did get such information and confirmation from the other side that they have the TCC has the competence to finish this work on time.
Yes, we've discussed this, Dr. He. We've established that you were given the photographs, that neither Harry Yan nor John Hornblower said anything else to you about those photographs, aside from the fact that these were the photographs that Wei He requested, and that yes, you did form a conclusion about those photographs, but the conclusion was was your own conclusion, was what you drew from looking at the photographs yourself.
But I think that's a reasonable conclusion concluded from the information provided by TCC.
Well, that's a matter of opinion, Dr. He. I just want to establish that the basis on which you drew that conclusion, when you say information provided by TCC, the information is those drawings and photographs which Harry asked for in that email that we saw on the 3rd of January 2016. And that's the basis on which you drew the conclusion that you drew.
Yes.
Thank you. I'd like to end with some questions about those components as well. Those components were components that were intended for a project originally in Algeria, wasn't it?
Yes.
Now, doesn't Dalian have a different climate from Algeria?
Yes, I agree.
Dalian has a much cooler climate.
Yes.
And Algeria has sub-zero temperatures in winter and is hot and humid in summer.
Yes.
Now, I note what you say, Dr. He, that, well, despite being a PhD in nuclear engineering from MIT, one of the foremost engineering universities in the world, despite working in Halliburton for 13 years on nuclear power plant projects around the world, you say that you're not a specialist in construction of nuclear power plants. But bearing that in mind, I'm interested in your opinion. Given the differences in climate between Dalian and Algeria, wouldn't the parts, have had to be modified if they were originally intended for Algeria to suit the conditions, had to be modified to suit the conditions in Dalian?
I think the temperature and the natural factors difference between Dalian and Algeria is a common knowledge, either to us or to the TCC site. I was also very surprised that the temperature factor would become the factor X and defer the whole project for another half a year?
Well, you didn't quite answer my question, Dr. He. The question I had was whether, given those differences, there would have to be some modification to alter or to suit the different conditions in Dalian.
I think I'm not in a proper place to answer this question. And I do think TCC is in a better place to answer this question.
All right. I'll leave it at that. I mean, despite your PhD in engineering and your 13 years in nuclear power plant projects around the world, but I will leave it at that. No further questions. Thank you.
Thank you, Mr. Lee.
All right. So that brings us to the conclusion of the demonstrations. The first thing I want to say about cross-examination is that there's no mystery about it. This is not some sort of magical process that you need some kind of secret instruction in before you can engage in cross-examination. It is actually a methodical process. What you need to do in cross-examination, and what I did when I was preparing for this cross-examination, was to first of all look at what case I had to prove or disprove. And the main issue here was the claim against TCC by Walker was that TCC had misrepresented that it could complete the projects within a certain timeline, and that one of the reasons for that was that they could use these components for Algeria to transfer them to the project in Dalian. So you'd see that that's what I focused on in the cross-examination. And the other thing that I did with the cross-examination was that I generally, I think one or twice I veered from that, but generally, I don't ask a question I don't know the answer to. If you notice, most of the time, what I was doing was actually just putting statements that actually had been made in the witness's own witness statement or accepted facts and putting those to the witness. So the purpose of cross-examination is really to put your case to the witness, and also through that to put your case to the tribunal. So the tribunal understands what your case, and you're not asking a question you don't know the answer to. I know I veered off from that once, twice, but sometimes you have to when the opportunity presents itself. But you are in fact trying to show that what the witness says, either if it is correct, actually supports your case, or you may want to show that what the witness says, if it doesn't support your case, is not correct because you have a document which shows that it's not correct. Or perhaps you've got a witness statement that contradicts that and you think you can use that to at least put it to the witness. They may not necessarily agree, but you can use that to put it to the witness to show that what he's saying may not necessarily be correct. So it's actually a methodical process. And what I think would like to do now, if I can, is just very briefly put up for you the notes that I prepared. Because one question I think sometimes people talk about is whether you actually use notes or not in cross-examination. I think you should. You don't necessarily have to write out all the questions, but I think you need to have those notes. And let me just show you, if I can share the screen, what I did. And yes, share. So you should now see on your screen the notes that I prepared for the cross-examination of Wei He Tang. And you see that it's prepared in a methodical way. I've grouped it according to the issues I'm trying to address. I've got the questions there that I want to put to him. I've got the references there. And you see, I move on. When I'm moving on to a next issue, I identify it. And the next issue is identified. So the point about this is it is a organized, methodical exercise. If you're ever going to have a chance to ever succeed in cross-examination, you have to be very, very methodical about this. I've seen different ways. Let me just stop sharing the screen now. I've seen different ways in which counsel prepare it. Some people say you shouldn't really have any questions, just have some points. I think if you really want to be organized, it does help to have this broken down according to what issues you're trying to draw up, what are the points you're trying to draw. I've seen sometimes it's just written down questions on a piece of paper. I actually don't claim to have any proprietary rights over this. I learned this from a Queen's Counsel that I worked with in the past, and I found it to be a very effective method of doing it, and I've adopted it ever since. And I think it's a structured way of preparing the cross, and that's what the cross-examination is ultimately about. It's about structure. It is about preparation. Ideally, you should know your case. You should know the case better than the witness. That is a challenge sometimes, but it's possible. You can. Because witnesses' memories sometimes are not that good, and what you need to do is actually to do the hard graft of going through all the documents you can in the case, all the witness statements, and understand every single fact that you can. And it's also a bit of psychology, right? It's also a bit of psychology in letting know the witness that you're in charge, and you can do that in some ways. I mean, one is you let the witness know that you're in charge because you know the material. You know the material better than the witness. I remember in one of the cross-examinations I did a few years back, and I was specifically given this brief by the client. Not that I thought it was the right brief, but it's, I want you to shake this witness. I want you to make this witness, rattle the witness. And I said, look, that's not really my role, but I will do what I need to do with the cross, and we see where we'll get to. But we got to a point where we were discussing a particular part of something that happened. And I said, yes, I know that. And then I told the witness what she did after that point. And I saw her eyes open wide. And at that point, I knew I'd got it because I'd rattled the witness. I'd shown the witness that I know this case at least as well, if not better than she does. So the witness then got nervous. Because the witness wasn't in control. Other aspects of being in control would be, you saw that Kelvin and Nathan did a good job at trying to be difficult witnesses. The other thing I'd say is rather unfair that they had all the questions, well, almost all the questions that I was going to ask them in advance. I didn't know the answers, but they had the questions. And sometimes they didn't quite give me the answer I wanted. And then you have to go back, you have to go back and press for that question, for the answer you want. I mean, sometimes you're just not going to get it and you have to move on. You're not going to score every point, but there's some obvious ones where you could go back and press. And I did. I pressed until I got the answer I wanted before I let the witness move on. The other point I just want to make, I'm keeping my eye on the time, is that every question you make should have a purpose. I mean, it's cross-examination is a very, very risky exercise for both parties, actually. For the witness, you never know what the witness is going to say in cross-examination. So if you were the counsel on the side or from where the witness is from, you'd be nervous. And the same for the cross-examiner, unless I've definitely got a document which clearly contradicts or supports the point I'm putting to the witness. I'm going out on a limb sometimes, and I had to go out on a limb during some of that cross because Nathan and Kelvin were creative enough to stray away from some of the points that I'd given them. So I was going out on a limb there, and this comes to experience. You got to figure out whether you should do that or not. It's a bit of a calculated risk, but generally you really want to avoid doing that. So every question you put really should have a purpose. And some people say you should know the answer to every question you put in cross-examination. Never ask a question you don't know the answer to. Keep the questions short as possible, and close questions. So generally, it is, I put a point, and really the answer is yes or no. Try and avoid asking why. I know I did that once or twice, and sometimes you do make a calculated risk in doing that. But generally, you don't ask why you did something. You put a point to it. You said this happened. And you really, what you want is yes or no. And if he doesn't agree, if you ideally you have a document or some evidence which then shows that he should agree with you, and his answer cannot be a fair answer if he doesn't agree. I think the other points you want to note would be firm, and you note, well, at least I hope you saw that I was firm, but don't be unnecessarily aggressive. Be polite, be firm, and this is somewhat towards your personality. I guess I could have been more gentle with the witness, but it's a question of personality. But the thing is, don't be unnecessarily aggressive. Now, some counsel, I don't know why, seem to think that it helps to shout at a witness or to be very aggressive with the witness, to put the witness down unnecessarily. And it doesn't work. It really doesn't work. I remember being in a hearing this time as a tribunal member, where that's what the counsel did. He shouted at the witness. He'd go back to the witness. He wouldn't let the witness finish an answer. He would say, "No, I just want yes or no. Tell me yes or no. That's all I want to know." And when he finished, one of the other arbitrators turned to me and he said, "That's a great example, of how to get nothing from the witness and piss the tribunal off at the same time." So aggression as counsel in cross-examination generally does not get you anywhere. If the witness is not cooperative, I think everybody can see that, including the tribunal, and there's no need for you to be aggressive about it. In fact, the gentler approach there would work well enough that you can see that he's not being cooperative. And that works well enough. And as I said, try not to have long questions. I know some of the questions I put had to be long, and some of them you gave the witness enough room to start to wriggle. But generally, try not to. You have to keep the question short, to one point per question, and ideally just a yes or no answer. The other thing that's important about the cross-examination as well is also knowing when to stop. That's critical, knowing when to stop. Sometimes you can ask one too many questions, and then you allow the witness to start wriggling out of the answer they gave. Again, coming back to a case I had again where I had to kind of shake the credibility of the witness. It's not easy. It really is not easy. I mean, cross-examination most time in commercial cases is dead boring because it's about facts. It's not a Perry Mason moment. You're not going to get the witness breakdown and say, yes, I did it, and stuff. It's not easy. But I had to shake the credibility of the witness. And I hadn't quite reached the point where I wanted to finish the cross-examination, but I was asked by the tribunal to put the case to the witness, which I did. I put the case to the witness, and the response I got back was shaken enough that I figured, even though I had some more questions to put, that's the point to stop. Because I'd gotten as much as I think I was going to get out of it. And I mean, it wasn't, yes, I did it, I'm guilty, but close enough that I thought that was the point. This is about as good as I'm going to get, and I better stop here. Any further I go, I'll just make it worse. So knowing to stop is probably as important, and also using the witness's own words. So you notice that quite a lot of the time I was actually putting the witness's own words back to the witness, because I thought, that would be helpful for the case, and that we use the witness's own words. And final point is, keeping it out of the time is, try your best to end on a strong note. And that comes back to the point about knowing when to stop. Try and end on a strong note that you show that you're in charge, you kind of got what you wanted, and end it there. Not always possible, but so Nathan did give me a bit of a challenge right at the end, as I thought he would, because he was going to wriggle out and say he doesn't really know anything about nuclear power plant construction. So you try and end on a strong note, and I tried to recover from that by making him sound as if, well, you're not being very cooperative there, by saying you really don't know the answer to that. I mean, you take what you get and make the best of what you get. I think I better stop here because we're getting close to 7, and we need to get reactions from our non-native English speakers from Wei Na and Yanhua.
Thanks, Stephen. Perhaps if it's okay with you, Weena, I'll just ask Yanhua to talk first on this, as we've got not an awful lot of time, and I want to be fair so that everybody has a chance. And hopefully our guests will agree to stay just for a few minutes after 7 to hear both of you speak.
Yanhua. Okay, thanks, Ben. So I'll go first. I think for many, I would say, Chinese practitioners, the primary issue with the cross-exam is, again, not about language, but it's the problems that we are often not familiar with the cross-exam setting or cross-exam rules at all. Because that in the Chinese domestic litigation or arbitration, we rarely have to cross-exam a witness during the trial. The Chinese litigation and the Chinese arbitration, we primarily focus on the documentary evidence. And when we refer to cross-exam in the Chinese context, we actually refer to the attorneys talking about the party's opinion on the other side's documentary evidence. So I think the problem is that we are not familiar with the cross-exam skills and the rules at all. So when I started to work on international cases, I actually received very good guidance from foreign counsel, such as Steve. So as long as we started to learn more about the cross-exam skills and the rules, we actually can try to obtain the necessary skill to do a good cross-exam. I don't have much to add to what Steve just said, because Steve is the expert, right? So I do not ask the questions that you don't know the answer. That's what my foreign counsel or the barrister told me. And I started to learn that, and I started to cross-exam in international arbitration. Well, I cannot agree more with what Steve just said, that because without the good training, we got the impression from the TV drama that whenever you do cross-exam, we got the incorrect impression that the purpose is to try to destroy the witness, but it's not the purpose. So I cannot agree more with Steve that always try to be polite, do not unnecessarily be aggressive. That's some lessons I learned from my past experience. Yeah, that's my brief reaction to what Steve just said.
Thanks, Yanhua. Weina, anything more to add?
Very brief points, and in addition to my agreement to Dave just said, because I think I completely agree with Yanhua that the major issue with practitioners in mainland China is that because they're not very familiar with the entire process, including what the purposes are of having cross-examination, and as well as the method, as Stephen has just said, how you can use the method to prepare cross-examination. But from my own experience, I think compared to oral advocate submissions, to make submissions in front of the tribunal, actually cross-examination is easier for non-native speakers because it's conversational and you use very short sentences, and in each sentence you deliver a very simple message. So it's more about planning and knowing your documents as opposed to like conveying very complicated messages. So actually it's very easy. It's easier for non-native speakers. So I would encourage, for junior lawyers in this market, start with cross-examination and try to sort of learn and practice if you have an opportunity. And then secondly, I also agree that, sometimes we see that when you see like a counsel from a civil law background, sometimes they tend to consider this as an opportunity to sort of interrogate or confront your witnesses. And so sometimes you see people coming into the witnesses and just sort of directly asking questions like, oh, you said this in your witness statement, but you didn't do this, did you? That type of question that actually sort of, which actually opens opportunities for the witnesses to clarify on certain points or offer new information, which is not necessarily helpful for you. So I think, and that sometimes is a myth carried by common law background lawyers of as to the purpose of the cross-examination. It's not just about sort of destroying witnesses, revealing that they're liars. It's also about sort of getting admissions from the witnesses, getting new informations, which will help you to build up your case. So, as Stephen has just done, when he comes in to ask questions for Nathan, it's very clear. You can see it's very clear what the purposes of those questions are. So, for international arbitration practitioners, often, when you're preparing your case, when you prepare your submissions to the tribunal, for each of the witnesses what the purposes, what are the points that you want to score from each of the witnesses, and in relation to each point, what are the key documents, what are the key statement that he has made in his witness statement, and surrounding those you will be sort of planning questions, and you will be building your questions using the building blocks as opposed to just coming in and confront your witnesses. So I think that would be my advice, and you need to do it in a very methodical way, as Stephen has just said. That's all from me.
Thank you, Wayne. Well, look, we were going to leave a little bit of time for questions, but fortunately we haven't had too many questions, and I'm conscious, of course, of the fact that we are now a little bit over. So I hope our guests today won't mind if we do not stay for questions, and we'll let them get on with their day. So perhaps I could just end by just saying a huge thank you from the HK45 to Stephen and to Yanhua and Wayne for sharing their insight, and also to Nathan and Kelvin for being the sacrificial lambs and volunteering to be the witnesses today. Thank you also to the HKIC, to Chloe and Stella for their help in putting this together. There has been an awful lot of work that's gone into this, of course by Stephen, but also by everybody else involved. So thank you so much, and I do hope you enjoyed it. HK45, of course, runs many of these sessions, so please do go on the website and look at when our next sessions are running. We're running sessions every month, and keep in contact with your stories about attempts to for effective advocacy in English. If it isn't your language, we want to hear more from you all. So thank you again to everyone, and thank you to everybody who's attended and stayed a little bit longer after 7 o'clock. We do appreciate it. And that's the end of the session, and thanks from us all.
Thank you very much, Ben, again.
Thank you, Ben. Thank you, everyone.
Thanks, everyone.
Bye-bye.
Thanks, Ben.